my name is Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues, so please subscribe to our channel. You know, I remember a lot of movies that deal with the topic of divorce, and some of them are great classics. You know, The War of the Roses was one that comes to mind, Bonfire of the Vanities. You know, there were these different kind of movies, Kramer versus Kramer, who could forget that? I mean, there were different kinds of movies that really dealt with the issues and how you handle divorce as it relates to Hollywood's version. Okay, so the question is, as it relates to the Michigan Circuit Court's version, okay, because that's who you're likely to be in front of, how's that going to work? And how do you prove things like emotional abuse and all that? Well, the good thing is, a long time ago, the Michigan legislature realized that, you know what, it's very, very challenging to prove, abuse from the standpoint of emotional abuse, verbal abuse, psychological abuse. You know, if somebody punches somebody in the face and they got a black eye, you can probably more readily prove that abuse. But these other kind of intangible abuse is rather hard to prove, which is why Michigan, it's one of the reasons why we're a no-fault divorce state. We don't require you to prove that in order to get your divorce. And if you want to prove it for the sake of getting a property division that's unequal, you can try, but you have to remember that even in cases of horrible, egregious fault, the court tends to not deviate significantly from a 50-50 split. Now, if you want to bring that up, not as it relates to the divorce, and not as it relates to the property, but as it relates to the children, and as it relates to the custody, you want to say the other side is mentally abusive to the children, well, that's something worth bringing up, because the court needs to know that. The court's threshold for protecting the children is considerably lower. The court would rather err on the side of caution. So if you can bring in some significant proofs, even if those proofs might not have necessarily gotten you more property, they still might get you a better disposition in custody, because the court takes a different view of that. It's more of a protective view. So how do you prove the emotional abuse? Well, for example, if you can prove that one child is treated differently than another, that there's a direct favoritism of one child to another. Those are ways to show emotional abuse. Another way to show emotional abuse is, for example, if one child is given more privilege, one child is punished more severely. One child, for example, it loses a privilege that relates to his or her specific hobby when they do something wrong, whereas another child's hobby is left intact and there's a different kind of punishment. These are all cases that we've handled where we've demonstrated this type of abuse as emotional abuse, but it's very, very case specific. You may have a case for it, you may not. Obviously, the lawyers are going to listen to what you have to say and determine whether or not what you have is enough of a burden of proof to show it to the court and go forward with that. If you have any questions about that, of course, reach out and we'll be glad to help you out.